has a lot of work that needs to be done to, I don't know why you're giving me the attitude.
No, I'm not trying to. I'm sorry.
Yes, you are. Either that or it's because you're high. I don't know which one it is, but you're giving me attitude, and that attitude will most likely be readjusted by me at the Bexar County Jail. So I don't know if your attorney told you this, but I can send you to the Bexar County Jail as a condition of this probation, and I can also send you to the state jail facility as a condition of this probation for attitude readjustment. Do you want that?
Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
I have also.
I wasn't talking to you.
Okay, that's nice.
You know what, young man? I'm gonna tell you one thing right now, and I'm gonna tell you, you better check yourself. So I'm gonna give you a minute to go out into the hallway. Otherwise, what's gonna end up happening is you're gonna be in contempt. I was talking to Miss Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now. And when you feel like you can behave yourself, then you can come back in.
I can't tell because it's not entered in the computer system. It's a felony case, and for whatever reason, the court has decided that we don't enter felony cases until the day of the hearing, I guess. I don't
Counsel,
understand.
your sarcasm is not acceptable.
I'm
And
not
that is
engaging
not,
in any
and
sarcasm.
that, please don't interrupt me. And that is not what the court has decided to do.
At any time, intentionally, negligently,
Not
Any-
intentionally, I was backing
I
up.
don't care. Stop, listen to my
Sorry.
question. Did you at any time, either intentionally, negligently, recklessly, in any way, shape, or form, damage their truck?
No,
So at no time, through any actions of yours, at no time did you damage their truck? It's easy, yes or no?
can I explain?
No, yes or
Sorry.
no?
No,
So you've never at any time did any type of conduct in any way, shape, or form that would have done any damage, a scrape, a nick, any type of damage to their truck? Yes or no?
see, sorry, it's hard for me to
It
answer.
is not. It's a yes or no.
Well, I'm not trying to lie, but
It sounds like you are.
no, because their son backed up. I was backing up and he cut me off. And so that's
Don't
when I
care about
bumped it. So I,
explanation.
that's why it's,
Don't care about
I'm not,
explanation.
so then I guess, yes, I guess I'm not really sure because it wasn't intentional and that wasn't ever my main,
Miss Mott,
you know.
zip it.
And then they live with their dad.
Okay, she's
In joint custody.
time out. You're being very dishonest and slippery with me because I asked you, my mind is a steel trap, but I wanted the court reporter to read back because maybe my mind is failing, but I highly doubt that. You told me that your children were living with you and their father, and you said the other father he's not a part of anything. Now you're telling me, oh no, he doesn't live with me. It's on and off. You've been dishonest with me from the very beginning. You were dishonest when I asked you if you're going to be positive. You were dishonest about that. Then you were dishonest about Bloodworth. I don't even know if this is this person's real name or not. Then you were dishonest about Sarabia. At first, and later you said he was the father of your children. Now he's not the father of your children. You're just being dishonest all across the board with the court, and I don't appreciate it.
Have to feel about it. But Ms. Bacon, your conduct in this case has been abhorrent. You have absconded over and over again. You've never complied with bond. You make excuses for it. Your response to the assessor, the way you responded to them as recently as 10 days ago. You say you got cleaner in the jail, but you were already in jail for a month when you saw her and you still acted the way you acted.
Together, and he can still have his complaint, I guess, that he has, and maybe if he'd listened to his attorneys, he won't have the complaint, but I'll let him do what he's gonna do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion, all right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person. Because if he wants to play that way, Mr. Brown, what do you want me to do with that?
Your Honor, I will leave this completely in the court's discretion. Absolutely.
Okay, let's bring him up. I'll set that in person. That's at 2 p.m. on the 22nd, and we'll see how he wants to act that day. His request for withdrawal of counsel denied.
Prior to this one, I tried to work with them, but could you please stop? This is why I really just don't feel like I should work with them.
Just a minute. Mr. DeMayo?
Yes, Your Honor.
Sit down and pay attention. You're in a court proceeding. Don't get up and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street. They allege your kids are dancing on the roof. They're breaking windows out. There are other allegations that have led them to terminate the tenancy. You haven't paid the rent since September and you're full of indignant disgust.
McKnight.
Oh, you know I'm pregnant. I can't do all that.
Miss McKnight, you got to stop getting pregnant, ma'am. I know that's not a thing that people supposed to say, but you keep bringing kids into this world and you can't take care of them. Please stop.
Well,
it's like every year I see you, you got 2 kids. Miss McKnight, this is not fair to these babies. You keep having, what are we on, number 8 now?
No.
7?
Yeah.
Miss McKnight, you know you can have sex without having a baby, right?
Case sits right now.
Okay.
Don't interrupt me. We're gonna have a way to you know what? Tell you something, Mr. Montgomery. No, you'll hear me. I'm gonna tell you right now. I expect people to conduct themselves in certain ways in my courtroom. I don't know, just listen to me. I don't want this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever, you can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something, what comes out of your mouth, because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
Yes, Your Honor.
Thank you.
Supposed to spend the night with him and I was supposed to pick them up that morning.
No,
That's why I was there.
so you're saying there was not a CPS safety plan in
Oh,
place?
yes, there is. Mhm.
All right.
And the plan that me and Jacob had came up with was for his dad to be on the plan and my mom to be on the plan.
Please, what I'm saying. I just want to just guide you.
No. I want to listen to what she's saying because she's changing her story to me.
What, may I have a minute?
No,
Thank you.
she's on the witness stand. So go for it.
But anyways, I'm very remorseful for what happened that day.
No. Let's go back to the safety plan business.
Yes,
So you're saying there was an agreement with the safety plan for what?
just for my mom and his dad to be on the safety plan. That's it. That's all I was gonna say.
No, your mom just testified. You heard her testify that says she was not considered for the safety plan. So she was not on a safety plan.
Coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's
anyone.
not, no,
You guys
it's
are
not
talking
going to
down
happen.
as if I'm a
It's
slide.
not going to, you want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor, that wasn't my attempt.
Response from JSG, and I'm gonna tell you, lying to me is a problem. This is the response about the tether. And don't tell me your DOC agent took your tether off, because what I'm about to read to you, your DOC agent did not do. Good afternoon. It was retrieved by one of our agents who located the device out in the field on November 30th. I believe near the location of removal. I did have a cut strap and the charger was not removed. So tell me again how your DOC agent cut your tether off of you and threw it in the field.
When I got off Google, October 13th.
The tether was removed on or about November 28th, the day you missed court. Mr. Ray, tell me another story.
I cut the tether off.
Yeah, you cut the tether off.
You've had 3 motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're looking at up to 10 years in the prison. Deputy Laura, could you do me a favor? Could you place the handcuffs on him, please? Each time you come before me, I know I've told you you're looking at doing 10 years in prison. Obviously, your mother is not laying down the law with you at home.
I got in the file the date of the hearing.
Well,
And
that's
it
why we need a
clearly
hearing
says-
then, because there was 2 orders.
Sir, you're entitled to have a hearing, but I'm gonna tell you one thing. If you have a hearing, you better check that attitude outside. Cause I don't accept
I don't
that.
have an attitude.
I
Can you
need-
not hear me? I'm speaking up so you can hear me. I'm talking on the phone.
You got one. I don't accept that because I don't talk to you like that.
So ma'am, I'm just gonna give you a fair warning. If you think I'm not, you didn't think I was serious about my last order. If you think I'm not serious about this order, you're gonna find yourself very wrong. Because if you're not in that jail by 6 p.m. this evening, I will send somebody to get you.
I understand,
you.
Your Honor. I'm sorry that you feel that way, and I hope we can resolve this
You
matter.
better be quiet, because she's about to pick up a whole lot more, Miss Anderson.
And it may be moot anyway if the treatment program does not allow him to go. At this point, I'm going to put this on for September the 12th, 2023 at 10 a.m. And you must submit the documentation.
Vincent, I'm gonna come see you today. Let the judge finish talking. Sorry, Your Honor.
Mr. Vincent Klein, if you continue to act up, I'm going to not consider this at all. Well, he seems to not want to stop giving me that behavior, so I can just say, forget it and not consider it at all. Stop it now. I'm tired of it.
Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Here, he's availed himself to the court every time that I've had anything to do with him.
Why
He's not
didn't he
letting-
turn himself in between the time I revoked his bond and today?
Just gonna come out to court.
Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I mean, I'm
way the wrong answer.
I'm sorry, man. Actually,
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client defendant to remand. Take you. Court's gonna stand in recess.
Okay, so let me explain something to you. Children cannot support themselves. And it appears to the court that you're just having children and allowing somebody else to support them. For example, If I were to have a child, I can't say, oh, cute baby, and then put them at Travis Park and say good luck to you. And that's what you've been doing with all of your children. You haven't raised a single one of them, and you haven't been working. So let me just tell you, I'm gonna help you with that. And I don't know why you're getting attitude with me. You haven't raised any of your children. None of your children are with you. You have an 18-year-old, 17. Here's the thing. You have an 18-year-old, 17-year-old, 16-year-old, 11-year-old, 10-year-old, 9-year-old, 7-year-old, and none of them are with you. You're not raising them. You haven't been working. You just told me in 5 years. You haven't been financially supporting any of them. Now you have a baby on the way. But
People versus Octavia Lewis.
Nicole Hughes on behalf of the people.
Sandra White on behalf of Ms. Lewis. Your Honor, Ms. Lewis is present. She does not wish to respond under this name, but she is present. I don't know if Your Honor can see her.
So what name today does Miss Lewis wish to respond under? Miss Lewis and I kind of know each other.
I resent that statement made by the court. It is my natural name. I was adopted, and then I incorporated my name. I am sorry, Mr. Sampson. I do not disrespect you, and I appreciate it if you did not disrespect my name.
Okay, so here's what we'll do. All right, before this gets too far afield, I know that this is the individual that I know to be Octavia Lewis, as we call her here. So what do you want to do in this case, Miss White?
Yes, I was appointed to this case. I had the opportunity to speak to Ms. Lewis this morning. We are asking for an adjournment so that we can get discovery.
Without objection, probable cause conference will be adjourned. Let's just do October 5th. October 5th, 2023.
I'm through.
9 a.m. Bond continued. Thank you.
Thank you.
You're disrespectful.
Court calls the case of the people versus Khalil Taylor Jefferson, 2 cases.
Nicole Hughes on behalf of the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Taylor Jefferson. Mr. Taylor Jefferson, if you're present, would you please state your name?
Yeah, I'm not surprised. He's missed every. Go ahead, what?
I was just going to say that I do believe that he was at the last court date. I tried to reach him before today's hearing, and his phone was not in service. I'm assuming just needs the bill paid. We would ask for an adjournment.
Oh, you think it's because of the bill?
That
has nothing to do with
work.
You think it's the bill? You just throwing that out there.
Because
no, it's okay. It's okay. It's all you had. I mean, I get it.
Thank you. I appreciate that.
Because it may be why he missed his test too.
Oh, well,
no,
he's
that's
been
okay.
trying.
No, you don't have
He's
to
been
answer
working on that for a
I'm
long
just saying.
time.
I'm just saying.
For a while.
Bench warrant will issue for defendant's failure to appear in both cases. Bond is set in the amount of $25,000 cash surety. Those warrants will issue immediately.
Thank you.
Thank you, Your Honor.
Versus Sean Jenkins.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jenkins. Mr. Jenkins, can you unmute your device and state your name for the record? And please remove your hat, Mr. Jenkins, while you're in court.
Okay, just a minute. I gotta go over here.
Your Honor, we are asking for an adjournment of today's probable cause conference in order to have some additional conversations with Mr. Jenkins, as well as the prosecution in this case. My understanding is that Mr. Jenkins does have a request that he would like to address with the court himself.
Really?
That's correct. Mr. Jenkins?
Probable cause conference will be adjourned October 5th, 2023. 9 a.m. What do you want to address?
Yes, hello, how you doing this morning, Ghana?
I can't hear you.
Okay. I said how you was doing. I want to address the public defender representing me. I feel like there's a conflict. Well, I know there's a conflict of interest. And the public defender represent me because my wife, her cousin, works for the public defender law firm, and she just threatened me like 2 weeks ago. So I don't feel comfortable with the public defender representing me. I don't want to get into detail about everything that happened and her and what she did, but I don't think that it would be in my best interest to be with someone that she works.
So who is it you say is who do you have the problem with at the public defender's office?
I believe her name is Roberta Higgins.
Okay, and what is she to you?
She's my wife's cousin.
Oh, she's your wife's cousin.
Yes.
Okay, and so what does that have to do with your case?
Well, see, what would have to do with my case is because like 3 weeks ago, she called and threatened me, talking about sending some guys over.
She was gonna send some guys over.
For me, that she would be trying to cause issues or problems with me. So, I know she's been working there for quite some time, and I know she know a lot of people that's in there, and I just don't feel that
she knows a lot of people that she gonna send over to you.
Would be representing me the best of my ability on account of.
Okay, so
her,
hold on a minute.
Not liking me.
Just hold on, Miss Apple. Do you know anything about this?
Your Honor, Mr. Jenkins did make it clear that he would be requesting for our office to withdraw. I contacted management regarding his request, and at this time have been informed that there is not a conflict that would affect his representation by our office, but that Mr. Jenkins was free.
And so, Ms. Apple, as of today, have you been contacted by anybody in the public defender's office to subvert, not zealously represent, or fulfill your duties as an attorney regarding his representation?
No, Your Honor, not in any way.
I didn't think so. Motion for withdrawal or motion to force the public defender to withdraw is denied. We'll see you October 5th. Bond continued.
Thank you.
Court does call the case of People versus Robert Welch.
Yes, sir, Your Honor. Alex Chabalowski for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Welch. Mr. Welch, would you please state your name for the record?
Robert Jason Welch.
Your Honor, this morning I received an offer from Mr. Chabalowski that I think Mr. Welch would be interested in, but I do need an opportunity to discuss it with him. We are asking for a 1-week adjournment, and we'd also like to address the issue of bond.
Well, you guys are going to have, if this is not a brief bond motion, you guys are going to have to file these in writing, but go ahead and address bond. Probable cause, September 21st, 2023, 9 a.m. Go ahead with bond.
Your Honor, Mr. Floyd, pardon me, I was looking down and wrote next to the wrong name. Mr. Welch did miss court previously. However, since that time, he has participated in inpatient and is currently enrolled in outpatient substance abuse treatment. I did receive verification from his aunt of that completion of the inpatient treatment, and I forwarded that to Mr. Chabalowski just a few moments ago. It indicates that he was at Meridian, and in addition, and let me back up, he states he was there for 30 days, and it shows a completion date of, I want to say, August 25th. In addition, I have provided Mr. Chabalowski with verification that Mr. Floyd is participating with MRS. He is
Mr.
also.
Welch.
Pardon?
I'm Welch.
I do not know why I keep doing that. I am so sorry,
right.
Mr. Welch.
Okay.
That Mr. Welch, I'm saying the right facts but the wrong name. I'm so sorry.
Okay, that's okay.
Okay. That he is participating with MRS and that he is also in outpatient treatment. We are asking, and he is residing with his aunt and has family support. We are asking that he be granted a personal recognizance bond. The offer is a misdemeanor use, and I do think he'll be interested in that.
Response to the people.
Judge, my notes showed that he was gone since January before being picked up. I'll leave it to the court.
Motion for bond reduction denied. Bond will continue.
Sir, I've been like 50 days sober. I'd be very grateful and blessed for a personal bond.
So you think if you keep talking, it's going to change? Motion for bond reduction is denied.
Oh, I didn't that hearing. I had a hard time. I didn't even hear that, sir.
Yeah, okay. Well, denied. They said it louder. Thank you. Crazy People versus Mohammed Al Akhtar.
Marie Rosinski on behalf of the people.
Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Mohammed Al Akhtar. Mohammed, can you unmute?
Yes.
They're so
State your
cute when they're little.
Yeah, Mohammed Al-Ashkar.
Al-Ashkar, sorry about that. Your Honor, we would like to set this matter for preliminary examination, and I'd like the court to be aware that Mohammed has been in and out of hospital, different hospitals. He's got surgery coming up within this week. The timeline for recovery is to be determined. He's also might have to have additional surgery. So I just want the court to be aware of that for the preliminary examination date. And I would also like to put...
You want me to set it out further, waiving your timelines, or you want me to set it for a normal schedule? Pray for the best. Tell me what you want, and I'll tell you what I'm gonna do.
I would do normal, but if I'm leaving that up to your discretion, Your Honor. I mean, if you know what, let's waive timelines and set it out, Your Honor.
You sure?
Yes, I'm sure. I'm sure.
That was his first case. It's gonna get better.
Oh, Your Honor, I've been in front of Judge Kunke too.
Have you?
Yes, I've interned in front of Judge Kunke, so you got some big shoes to fill.
Did you do this before?
Yes.
No, I'm kidding. I'm messing with you. Preliminary examination will be set in person. Well, no, he wants it. He just waived the timeline finally. So we'll just set it October 10th, 2023, 9 a.m. before Judge Burke. Finally, we
Your Honor, if I may,
yeah.
Just for my client's clarification and on my end, can we put on the record the tether conditions for my client? Because I see a hot zone on my end, but he just wants to know.
You see what?
I see a hot zone on my end, but he just wants to know if he can go to work and go get his surgery and take care of his own matters. If we can state that on the record, please.
Man, I have home confinement.
Okay. Is it possible that he can go take care of his matters outside of his home?
I guess, yeah, sure. But have you talked to the prosecutor about this?
I have not, Your Honor. I just wanted to clarify it first.
So somehow I figured that. So if he's got surgery and other things, maybe what you want to do is talk to the prosecutor, see if you guys can stipulate to something, send me an order. If not, I'll set it for a motion if you have to have a motion before his next day, even though I've already set the exam, or you can go to Judge Burke directly.
Thank you, Your Honor.
All right. Anything else?
Nothing
further. Are we
here.
finally done with this one?
We're done. I'll see you soon.
Okay, good. All right. Bond continued. Thank you. Is it Lohendorf?
Nimish Ganatra, First Assistant Prosecuting Attorney for the People.
Edward Drukas for Scott Lohendorf.
Mr. Lohendorf, can you state your name, please?
Scott Lohendorf.
Thank you. All right, what are we doing?
Your Honor, I'm asking for one last brief adjournment. I'd ask for 3 weeks. I am in receipt of a progress report from Community Corrections in order to facilitate plea negotiations. I want to see a little bit better of a progress than he's been providing the court.
Without objection, probable cause October 5th, 2023, 9 a.m. or Zoom invite indicate, bond continued.
Your Honor, and I'd want
Yes.
the court to remind the defendant about the community corrections obligations. And among other things, it's my understanding that he left the state to go to Ohio. And maybe he's just dumb. He wasn't paying attention to the magistrate when the bond conditions were read, but he's getting pretty sloppy with this. And I want him to be aware of the consequences of him violating any of the conditions of the bond.
What do you mean he went to Ohio?
Your Honor, I can explain. In discussions with the prosecutor, there was a missed test. In explanation of that, he did go to a golf tournament. He was a caddy for a U.S. amateur who competed in a tournament, the USGA 4-ball tournament that was tucked into the corner of Ohio. And when I was just going over this with him, that came out from him, and I reiterated, did you understand that you can't leave the state? So I think it was something that he overlooked, and I think I've been very clear with him as far as what those conditions are. And I don't believe there will be another mistake by him.
Sir, you understand that?
Yes, Your Honor. I did not at the time know that I wasn't allowed to leave the state, and I didn't want to bail on my buddy that day. I've caddied for him all over the world, and it's a huge tournament, and he qualified for nationals that day, but I totally realize now that I wasn't supposed to do that.
Congratulations, but he may not be able to go with you any other place if I were to revoke your bond.
Yes, I understand that.
All right, anything, and now you're on a real short leash, because I want to see progress with this progress report. I know your counsel does in terms of this testing, but if I have one more mishap, we're going to have a problem.
I understand.
Or you're going to have a problem. I'm not going to have a problem.
Yes, Your Honor.
So you might want to take that sheet that you were given, your pretrial release order, go over that and make sure you understand everything that's on it. And if there's something on it you don't understand, you need to get to Mr. Drukas so he can explain it to you.
Yes, sir.
All right, I'll let bond continue at this point. Thank you.
Thank you, Your Honor.
The next date again.
October 5th.
This courtroom session quickly turns intense as Judge Vonda confronts several defendants over dishonesty, probation violations, disrespectful behavior, and repeated failures to follow court orders. One of the most dramatic moments begins when a defendant arrives with an attitude, and the judge immediately warns him that his behavior could result in being sent back to jail as a condition of his probation. When he continues interrupting while the court is speaking with someone else, Judge Vonda orders him into the hallway until he can control himself, making it clear that disrespect inside her courtroom will not be tolerated. The hearing then becomes even more serious when the judge questions another defendant about alleged damage to a truck. She demands simple yes or no answers, but the defendant repeatedly tries to explain the situation instead of answering directly, frustrating the judge. She then accuses him of being dishonest about several important details, including his children, his living arrangements, and previous statements made to the court. The judge points out that his story has repeatedly changed and tells him that his conduct throughout the case has been unacceptable. In another matter, the court deals with a defendant who has repeatedly violated probation and allegedly removed his electronic monitoring device. When he claims that his supervising officer removed the tether, the judge reads evidence showing that the device was actually found abandoned in a field with the strap cut. After realizing that his explanation does not match the evidence, the judge orders him into custody and reminds him that he has already been warned multiple times that he could face up to 10 years in prison. The session then shifts to another defendant facing housing and family problems. He asks for more time because he claims he has been struggling financially after major surgery and insists he has made several payments toward his rent. When his frustration turns into an argument with the court, Judge Vonda immediately shuts it down and warns him that yelling or talking over the court will not be tolerated. Another hearing involves a defendant accused of failing to follow bond requirements, and the judge becomes furious when she learns that he allegedly did not turn himself in after his bond was revoked. She questions his attorney about why he was not instructed to surrender immediately and makes it clear that officers of the court have a responsibility to properly advise their clients. The most emotional moment comes when the judge questions a father about his children. He admits that he has numerous children, but none of them currently live with him. The judge becomes visibly frustrated, telling him that children cannot simply be brought into the world and left for other people to raise and support. She stresses that having children comes with responsibility and that repeatedly relying on others while providing little financial or parental support is unacceptable. Throughout the session, Judge Vonda's message remains consistent. The courtroom is not a place for excuses, changing stories, disrespect, or ignoring court orders. Whether the issue is probation, housing, child support, electronic monitoring, or parental responsibility, the judge makes it clear that every defendant is expected to take accountability for their actions.